Welcome, everybody. My name is Shane Keith. I'm here today with Theresa De Leon with Arden Trust. This is another episode of the KDI Wealth Alchemist podcast. What we'll be doing today is talking through how we partner with Arden and kind of the role that they serve with us and our clients in regards to complex trust needs, corporate trustee needs, as well as additional trust administrative pieces that they can play a role in. And I know that Teresa will give us more detail and we'll dive deep into that. But just wanted to share it as an intro. So we're going to hop right in.
Well, thank you. So I appreciate that introduction. I am the National Sales Director for Arden Trust, and I work with all of the advisors at Kestra and Blue across the country. We at Arden Trust, I'm going to give you a little background on Arden Trust, and then we can talk about our role as trustee and how we might serve some of your client needs going forward. Arden Trust is actually celebrating our 50th anniversary this year. So we've been around for a little bit of a while. Originally started in the state of Delaware, as many trust companies did, as what was then Reliance Trust Company of Delaware. But now we have been rebranded as Arden Trust Company. We are a member of the Kestra Holdings family. So we work very closely with advisors within Kestra Holdings. We have 7 offices across the country. We serve in a variety of roles, and we can talk about some of those today, but as corporate trustee, co-trustee, successor trustee. We do serve as executor, agent for executor as well. And we serve really in a variety of different types of trusts. Irrevocable trusts, corp rev trust, charitable remainder trusts, asset protection trusts, special needs trusts, all kinds of variety of trusts of that sort. And really what I want to talk about is a little bit of our model and how that differs from probably what people may have been accustomed to in the more traditional bank trust model. So first of all, Arden Trust is solely focused on trust administration. We do not do investment management, which is why we partner with financial advisors who have the expertise in investment management. And we think that's important for a couple of reasons. First of all, it provides more transparency on the fee side for clients, but it enables them to have what I like to think of as the best of both worlds. So an expert on the investment management side, a firm that they're comfortable with, that they may already have a relationship with, and then we come in the area where we are the experts in the trust administration. We don't have any desire to do anything outside of that, so we're not interested in growing share of wallet as a bank trust company might be. So we're not going to try to sell mortgages or lending or any of those other things. Our focus is really totally around doing what we do best, the trust administration. And our average, I think the trust officers on our team have an average of about 20 years experience. I have a little bit more than that myself, but not to age myself. But we have on average 20, and certainly certain certifications, trust certifications. We have a lot of attorneys and tax specialists. We've got a couple of CPAs on our team. So they have a variety of different certifications and licenses, expertise in a variety of areas. But our focus is on client service. That is what we do best. And when we serve as an administrator on a trust, we want to make sure that we are developing a relationship with clients, building that relationship, understanding the client needs, so that when we are administering the trust, we're making sure to do that in the best interests of the client, which is our goal as a fiduciary.
So can you actually expand a little bit? And you mentioned serving as a co-trustee, or even if you're serving as a sole trustee. We have an aging client base that as they get older, and depending on either whether if their family lives in other parts of the country, or let's say they were double income, no kid couple, and as they age, you start to ask yourself questions like, hey, who is going to help out or take care of our estate plan when that time comes? How do you guys kind of come alongside the client, either serve in a co-trustee capacity with a surviving spouse or serve as the corporate trustee settling out the estate?
So I'll talk about the latter first. When we are serving as an executor or a successor trustee on settling an estate, basically that's a really simple process, and we can work with clients around the proper language and kind of certain provisions that we recommend, and certainly working with them and their attorneys who might be drafting documents. Basically, we're going to be named in the document, and it is kind of a standby role We are waiting. We're named in the document. We'll have information to be ready to act, but we are not doing anything unless and until we're called upon. So
Okay.
typically in a two-income situation where there are no kids and no other families, we're going to be waiting until the second of the two passes. And that's typically the case. And I should say, you know, we'll work on language, making sure that they are understanding exactly what our role will be, how we will come into play at that time. And there's essentially no charge for those services. And that's an important element for people to understand. You can make those provisions, have that in the document named and ready, have us aware of all of these circumstances. We will have copies of the documents, et cetera. And our information will be with the attorney that might be ultimately preparing the documents, et cetera. But there won't be any cost to the client. And we can update that as we go over time, because typically that can be a very long time, hopefully, before we're actually actively doing anything. What we see more frequently currently is that we have a lot of situations where in that same situation, for example, the first of the two may pass, and then you have that second individual doesn't have any children, doesn't have any close family, relatives, et cetera, may have some advisors or friends, but typically they are aging along with them. So if they're their contemporaries and you're now, let's just say in your 90s, you really need to know that you've got someone else. And in a situation like that, we are often asked to serve as co-trustee. So even though we may be named in a document, typically for a successor trustee, we can be invited into the environment and into the relationship earlier. And that is often the case for, let's just say in that situation, an individual, let's just say in their 90s, may be completely capable and alert and fully functioning, but wanting to understand how that relationship is going to work and wanting to have us in there before a situation where they need that help. And so this way we can get to understand them, get to know them. They can feel comfortable with the trust officer who will be working with them. We can begin to ease into that. So for example, typically what will happen is we'll start to take over some of the responsibilities of paying bills so that you don't face that situation that I think we all fear, that you get to a point where you might overlook something and property taxes aren't paid or insurance doesn't get paid, et cetera. So you begin to take over that responsibility, and we can begin to coordinate the bill payments, any services that they might need, moving into that next stage so that when they are, either when they pass or if they reach a point where they need to have more health support, they might need assisted living, or they might have some kind of incapacitation of some sort, we're already on the scene, already in the mix. And it's an enormous reassurance, I think, for people to know that they have that and that there's someone. And again, we can do as much or as little over time. So typically, it's not as though you are losing control when you invite us into that relationship as a co-trustee, really working in concert with the individual. And they remain in control of, as I said, as much or as little as they want to. And typically, it's a gradual process. In the beginning, we might just be having conversations, getting to know the relationship, getting to understand what they are about and what their current challenges might be. And then over time, we might be picking up a little bit more and more of those responsibilities to make sure certain things get done, to assist them if they're making some decisions, downsizing a home, for example, or making some living changes. And we can provide support for all of that.
Yeah, we've seen where Arden steps in or a corporate trustee steps in, and even if it's as an additional safeguard to where the surviving spouse that's still alive and a relative comes out of the woodwork, we call them nail painters, but somebody starts to befriend them, and then it can eventually lead to fraud or take advantage of them if there's not another trustee that's looking over the situation.
Yeah, and this is actually the real purpose and benefit of trusts in general, right? To provide protection for individuals. So you have people, and obviously sometimes they're young individuals who are inheriting some of that wealth. So you want to make sure to protect them often from their own sort of lack of judgment or poor decision making, or just knowledge. You have a lot of times, even with on the other extreme, obviously there are a lot of unscrupulous people out there trying to take advantage. Yes, it's amazing that people come out of the woodwork, long lost relatives, friends who have incredible ideas for investments that they want you to partake in. And that's really a very dangerous situation in many cases. And you want to make sure that you're protecting people And so having the trustee in the mix really provides a little bit of added protection so that you know that no one's taking advantage of you, and we can make sure that anything that you need is provided, but that you don't have someone else who is taking advantage. And we do unfortunately see a lot of that. And it's just a great comfort to have, to know that there's someone else there and that you don't have to feel dependent on a stranger or someone else who might come into the mix.
We've run into situations where clients are trustees for other family members, and then they can either feel overwhelmed or all of a sudden it gets real messy real fast.
Yeah.
Can Arden step in midstream, and how do you manage that handoff if that's the case?
We can, and the transition is pretty much as it would be even if it were a professional trustee and we were coming in. We basically, and I'm actually working on one right now that's had an individual trustee for many years and in a professional situation, and it just had to come to an end because there were some conflicts that were created. When you have an individual, unfortunately, that's one of the issues that can arise. And so we stepped in. Again, we're going to get copies of the documents. We're going to make sure that everything is accounted for properly. And there's typically some documents that have to be created, an appointment and transfer. And we can create those. What we do is whenever we're brought into a situation, we'll look at it and say, based on the documents, okay, here's what we need to do. These are the steps that need to be taken. There are a couple of different ways that trustees can be transitioned. So we'll advise on what the appropriate route is given the documents in this situation. We'll help get those documents done and signed, and then we'll work with the prior trustee, whether it's a corporate trustee or an individual, to get all of the documents, to transfer all of the information. We will work with the financial advisors to make sure that the assets are intact. And I will say that we frequently find ourselves taking the place of an individual, because I think although the natural tendency for many people is to want to name an individual,
Yeah.
I think it is often viewed as kind of an honor that you bestow on somebody, a demonstration of your faith
Right.
in them, but it really is quite a burden. And people don't often realize, first of all, that there are technicalities, legalities, there are accounting issues. In the situation I was just describing, one of the reasons why the change is being made is because the accounting was not done properly, and that actually can endanger the tax status of the trust. And one of the benefits that you might be trying to achieve in keeping assets out of an estate and getting a tax benefit. And if the accounting is not done properly, that can be jeopardized. And so that was the situation here. So we've come in to try to help get that right. So we do have the expertise from a legal, from a statutory perspective, from a trust perspective, and understanding the terms of a document that in general, an average individual who's not in this field would not necessarily know. But also, I think the more significant thing and the more common thing is that there become sort of emotional conflicts. We had a situation just recently where there was an uncle who was the trustee for three young men, and they were in their late 20s and 30s. So they were young. And so obviously the protection was needed, but it became very contentious because their needs were different. And obviously the uncle trying to do the right thing and satisfy the requests of the three individuals, but also in a responsible way, knowing what he should and shouldn't think was appropriate. And it just became, he was quite overwhelmed, and it was really kind of a sad situation because he felt that his relationship with them was really jeopardized because there was just so much tension around the distribution of these funds. And so we get in there and we become a buffer for that. We can't be accused of favoritism. We have no emotional engagement. We are not, as I frequently say, going to be sitting at the Thanksgiving table trying to explain that what's going on. And so that gives us an opportunity to really be objective, to look at the terms of the trust, to understand the needs of the individuals, and to make good decisions around that. And also, as I say, always to protect them from some decisions that may not be in their best interests.
Yeah, to add to that, we conduct legacy planning meetings with our clients, next generation, so kids and also grandkids, and kind of talk through what the estate plan is, talk through what it's going to look like when mom and dad or grandpa and grandma are gone, what their expectations are, what the intentions are, and how the trust reads. So it is not, very specifically, so it is not the grandparents or the parents doing it, because to your point, the uncle, all of a sudden that relationship becomes contentious. It's uncles to nephews rather than an arbitrary person that creates a situation where it says, hey, we're just telling you how it's going to work from a legality perspective responsibly and effectively. It takes out the family aspect, it takes out the emotional aspect from the decision.
Yeah. And it's a very difficult one. And I find that people typically do not like to share too much information with that next generation.
Right.
For us, generally, the first step is explaining the document, the way it works, the way the trusts have been established, what's appropriate, what was intended is, and that's often not known beforehand. And so it is important to have a little bit of objectivity around that. We don't often think, we think a lot about wealth transition, but we don't often think that people inheriting that wealth, young people need some education and training around that. It's not a natural thing that everyone is comfortable with. And again, just to provide those guardrails around that. And that is an important part of what we do as trustees. I do want to say for Arden, we put a great deal of focus around client service because that is our role. It's about the relationship. It's about understanding not only the terms of the document, but how they relate to the lives of the beneficiaries and the people that we are working with, understanding the families, understanding the needs, and what's happening with the individual, whether it's someone older at that end of the life span, or whether it's a young person just starting out and trying to figure out their next career moves or educational moves, et cetera. And so we really have to spend time with it. We at Arden Trust have a very low trust officer to client ratio, particularly as compared to the bank trust companies.
Okay.
And I think that's an important differentiator for us. And the reason that we do that is we want to make sure that our trust officers have the opportunity to develop that relationship, to be that contact person. There is an individual trust officer assigned to every relationship, so it's not a call center or a group as it may be in some of the larger institutions. That trust officer has a trust administrator and a one-for-one relationship, which is also very unusual in the field. And then they have a whole operations team supporting them. But that is the primary contact for all of our clients. So each client knows who they should be speaking with, who they need to get in touch with. We want to make sure that they get 24-hour response time on any requests or any outreach. And as I say, it really is about developing that relationship. They don't have sales goals and do other things. Client service is their main focus, and that's where we, I think, differentiate ourselves from others. And for us, it's really part of working as a team with the financial advisor. We work very closely in partnership to make sure that we're meeting the needs of the client. So we are constantly in communication with the financial advisors as well, so that we can make sure that we both know what's going on, so the client has the best opportunity to make sure that they're being heard and getting everything that they need, and that we are meeting those needs together.
I love that. That one, I think it's very much how we at KDI like to operate, and feel that as the world continues to push towards efficiency and automation, that service becomes that much more valuable. And especially in times of life events, life transitions, and when things feel so chaotic or complex already around you, having somebody to stand with you side by side makes a huge difference.
Exactly. I think that is really the importance. We never forget that we're in a relationship business. And
Right.
I always say clients do not move from one trustee to another because of fees or other things. It's really always about service. It's
Yeah.
about whether or not I'm feeling heard. This is when I'm working with new clients, it's always what I hear, that they weren't getting response, or that they weren't understanding what they needed. They didn't feel, or they had a lot of transition and turnover, and
Yeah.
especially with a lot of the consolidation, a lot of the organizations, as you said, for efficiency, consolidating into these centralized groups. And when people don't feel that there's a personal connection, this is a business about service and it's about relationships. So you have to be able to feel that there's a connection and that people are interested in you and helping you.
Yeah, 100%. So this is more or less how advisors as well as clients interact with Arden. And from a perspective of proactive versus reactive. And you probably catch a lot of cases reactively where people are almost planning too late, where they're getting Arden involved either throughout the process or right as the process has started. Ideally, what does it look like from an advisor or client relationship to get started with Arden and have things in place prior to the need being there?
Well, I think that's a great point, and we encourage everybody to be thinking and planning ahead. We think a lot of people say, how much money do I have to require a trust? We think everybody can benefit from a trust.
Yeah.
Because you can avoid probate, there are privacy issues, but also just being able to plan ahead and know that something is in place that you've taken care of. And we talk about going through all of the basic steps of estate planning, if everything from the simplest to your beneficiary designations, titling of assets, etc., but making sure that you understand what it is you want to have happen. And that's the most important thing. And then I will say we work with a lot of clients. As I said earlier, we will be named in a document, and it can be, in most cases, it will be a long period of time, years and years and years before we might be called upon to act. During that time, there may be changes. And so that's the beauty of creating those documents. I think the biggest advice I give to people is don't try to make it perfect and account for every single eventuality. You will never complete a document that way.
Right.
At some point, you have to decide, this is it, let's finish it up. You can always make modifications later on if there are life circumstances that change that warrant that. But I will say that's probably the biggest piece of advice, because I think the thing I find that is hardest for people is to just like close the loop on it. You're constantly trying to anticipate everything when you really can't. So you want to make a document that is specific, but at the same time broad enough to allow for some latitude. As someone who administers the trust afterwards, if you are too detailed and too specific, you will tie our hands and make it very difficult for us to do what you want. And the other thing I will say is, I always tell people it's a balance between control and protection. What you really want is to protect yourselves when you get older and may need that extra support, protect your next generation, loved ones, etc. And you want to make sure that you protect them. You don't want to overemphasize control.
Right.
So there are some things that you might want to specify, but you want to give enough latitude because you never know what's going to happen. You can't anticipate what the needs might be 10, 20 years down the road. And so you want to make sure what you really are interested in is providing for your loved ones. And you want to make sure that you give enough latitude for that to happen, whatever those circumstances may be down the road.
Yeah, I can actually share a specific example of how you can really overdo or tie the hands of what the estate is ultimately trying to do. We had a client who had a federal estate tax issue. So the estate was large enough to where they had tax concerns at that level. But per the trust docs, they had specific liquidation events and bequests that needed to be given within specific periods of time.
Right.
Per the way the trust read, all within a matter of a month or two after the passing of the individual. And so assets had to be liquidated, changes had to be made, and ultimately impacted the use or the ability of the alternative date that you can evaluate a estate at.
Right.
And so it caused major issues overall just because of how detailed the trust really was written.
Yeah, sometimes you just don't anticipate it and you're trying to be too specific. So I do think that's probably the caution, but there are good standard provisions, and we do work with clients in conjunction with their attorneys as well. If they're drafting documents, we're happy to share kind of the benefit of our experience. We don't draft those documents for clients, but we certainly have read a lot of them and seen a lot of them. So we can talk about what we think might be just too burdensome, too restrictive. We can talk about things that you want to put in as special provisions. Simple things like always giving them some opportunity for change. Frequently, we're working with clients on court petitions because there's just no way to remove a trustee or an element of the trust. And so that's always a challenge as well. But again, I think having the document, getting the planning out, I think that in itself, when you get to that point, is enormously reassuring for people to know that they have a plan in place. And again, you can constantly revise it, but having a plan is better than no plan. I always say, the worst plan is no plan.
No plan. Amen.
So, and again, regardless of what you think your level of wealth is, it doesn't have to be something that exceeds the federal exemption level, which hopefully is going to get extended now.
Right.
But I think whatever your level of wealth is, it's everything that you have. So you want to make sure that it is handled in accordance with your wishes and whatever those bequests are. And if there are not individuals, if you have charitable interests, and we handle all kinds of special assets. So not just marketable securities, but real estate and oil and gas leases. And we just are working on an estate that had an incredible banjo and guitar collection,
Nice.
all kinds of things. And we also have a very large charitable group that works with charitable remainder trusts. And so we work with individuals on setting those up, whether those are lead trusts where they're getting the income and the benefit ultimately goes out to charity, or whether it's something where the charity is benefiting currently. We do work with them on the issuing of grant requests, et cetera, depending upon the type of charity, et cetera. So lots of different opportunities where we can help clients. And again, I think we try to be nimble enough to provide the level of expertise and support that the client wants. And that can be over a spectrum of time, more or less, whatever the comfort level is for the clients.
Yeah. Well, got one more question for you before we wrap up.
Okay.
And it's more or less future focused and kind of what you're seeing from a regulatory perspective. Do you see any upcoming legislation or regulatory shifts that could make trust even more relevant in the next few years?
That's a good question. And probably, so I'm not a tax specialist, but I will say it's always a benefit to have the trusts and the planning done. One of the things that I say is don't try to, and I'm actually thinking of Kara Murphy from Kestra Investments saying something very similar recently, which is you've got a plan for what you want to have happen, and you can't try to time the legislature, politics and what Congress decides and federal tax policy. That's a guessing game. You never win. And you never know what's going to happen. So I think you have to plan for the long haul. Then you have to make sure. I don't see anything coming down the pike specifically. I think the federal exemption and the things that we were talking about towards the end of last year and the beginning of this year, I think it's very likely those will get extended, which is a good thing. But you still have to make sure that all of your qualified money, all of your beneficiary designations are up to date, that things are titled properly. So it's really more, I think, about the basics, making sure everything is in place. I think long-term care is a really big item. Probably the biggest drain on resources that people have, and that where we see that gap is where there hasn't been any allocation for that, and that can eat up savings pretty significantly.
Yeah,
so
yes.
I expect that there's going to be more attention around that, particularly as lifespans are increasing, and that's likely to continue. And I think there's an opportunity for that. But I would say from our perspective, any plan is better than no plan.
Amen to that.
Begin that process. Don't be intimidated by that process. Start with the very basics. What is it that you would like to have happen? And then consult with your advisors, your financial advisors, your tax specialists, your legal advisors, and we're happy to be in the mix as an advisor for that as well. And figure out for your specific situation what makes sense. And I just say that as one last note of caution. I get a lot of clients who call that they heard something at a cocktail party. Just recently, we had somebody call and say, I want to talk about Nevada trusts. I heard this at a party and someone said I should be doing this. And you really got to just take a step back and just, again, everything is very specific to your circumstance. What are your needs? What are your wishes? What are your assets? What do you have? And then building a plan to meet your individual needs.
Yeah, just as your financial plan should be customized and individualized for you, so should your estate plan. And but the way that it all works together. So you hit the nail on the head there. Thank you, Theresa. This has been incredibly valuable. Thanks for sharing, and I hope you have a wonderful rest of your day, and we'll chat soon.
Thanks very much. I appreciate it. Take care.